Good afternoon. In the appeals case of Momčilo Perišić, the accused yesterday filed his notice of appeal against the trial chamber judgment, which was rendered on 6th of September this year. Perišić, former chief of the General Staff of the Yugoslav Army, was sentenced to 27 years of imprisonment after being found guilty of aiding and abetting murders, inhumane acts, persecutions on political, racial or religious grounds, and attacks on civilians in Sarajevo and Srebrenica. He was also found guilty for failing to punish his subordinates for their crimes of murder, attacks on civilians, and injuring and wounding civilians during the rocket attacks on Zagreb on 2nd and 3rd of May 1995. Perišić was unanimously acquitted of charges of aiding and abetting extermination as a crime against humanity in Srebrenica and of command responsibility in relation to crimes in Sarajevo and Srebrenica. It was the first judgment handed down by the Tribunal in a case against an official of the Federal Republic of Yugoslavia for crimes committed in Bosnia and Herzegovina. Last Friday, Vojislav Šešelj declined to enter a plea for the second time in his third contempt of the Tribunal case being conducted against him. The accused claimed that the registrar's decision to monitor his communications with his legal associates has left him without legal assistance. The registrar's decision followed his finding that reasonable grounds existed to believe that Šešelj abused the unmonitored communication means available to him for contact with his legal associates to facilitate the disclosure of confidential information on his website and in violation of judicial orders. In relation to the accused's claims made in the courtroom, I would like to reiterate that Šešelj is able to continue communicating with his recognized legal advisors through visits, telephone calls, and written correspondence, but such communications will be monitored. This decision was taken in accordance with the Tribunal's rules of detention and is also consistent with international standards. The registrar will review this decision after a period of 30 days. Šešelj has the right to appeal to the Tribunal's president. And finally, in relation to his third contempt of court case, the accused has 10 days from the date of the further initial appearance to enter a plea, and the scheduling order has yet to be filed to this effect. Turning now to scheduling issues, the trial of Radovan Karadžić, Mito Stančić and Stojan Župljanin, as well as that of Jovica Stančić and Franko Simatović, continue this week and next as scheduled. In the trial of Radovan Karadžić, the trial chamber is currently hearing the testimony of Ed Valjami, a journalist with the British daily The Guardian, The Observer, who was a reporter during the war in the former Yugoslavia. In the Stančić and Župljanin trial, the trial chamber is currently hearing the testimony of a protected witness who worked in the Republika Srpska State Security Service during the relevant period to the indictment. And in the Stančić and Simatović trial, the trial chamber is currently hearing the testimony of witness Vlado Dragičević, a former official of the Serbian State Security Service and close associate of Jovica Stančić, who is testifying with regards to all counts of the indictment. Also relating to this case, a hearing will take place on 21st of November at 3 o'clock in courtroom 3 under the Rule 54 bis of the Tribunal's Rules of Procedure and Evidence. This rule relates to orders directed to states for the production of documents. The hearing follows a request submitted to the trial chamber by the defense of Jovica Stančić on the 25th of October this year and Franki Simatović on 30th of May this year for a binding order to Serbia pursuant to this rule to produce documents. According to the defense, both accused, Serbia failed to provide them with a number of requested documents. Representatives of the Serbian government have been invited to attend this hearing, where the chamber will hear oral submission from the parties and Serbia with regard to the requests submitted by the defense teams. And also related to the trial of Stančić and Simatović, the Stančić defense has 5 witnesses remaining to call, 2 of which should be called after the start of Franko Simatovic's defense. Simatovic's defense has been directed to be ready to call its first witness later this month. And a housekeeping session has been provisionally scheduled for Thursday, 24th of November 2011, during which the further scheduling of this case will be discussed. And tomorrow, the 10th of November, status conference will be held in the case of Goran Hadžić at 3 o'clock in courtroom 3. Also tomorrow, further initial appearance will be held in the case of Ratko Mladić at 4 o'clock in courtroom 1 to enable this accused to enter a plea to the amended third indictment, which added crimes committed in the village of Bišina in eastern Bosnia and Herzegovina in July 1995. The further initial appearance will be followed by a status conference. And finally, next Tuesday and Wednesday, 15th and 16th of November, the Tribunal is convening a two-day conference on the global legacy of the ICTY. Leading academics, international judges and practitioners, state representatives, UN officials and members of the civil society will be brought together to explore the impact of the Tribunal's work on international humanitarian law and international criminal procedure, as well as the potential of its jurisprudence to shape the future of global justice and the advancement of human rights. All working sessions of the conference will be open to the press, and journalists wishing to attend should accredit via the ICTY's website. That's it from me, OTP.
No statement.
Questions?
I have one.
Okay.
Will the prosecution appeal in the Perišić case deadline expired yesterday and we did not receive anything?
Yeah, thank you very much for that question. After careful consideration of the trial chamber's judgment in the case against Momčilo Perišić, the prosecution has decided not to file a notice of appeal against the judgment. The prosecution has carefully scrutinized the trial chamber's findings and taking into consideration the high standard of review on appeal under the ICTY statute, particularly when it comes to factual findings, the prosecution has decided not to appeal. As the defense has filed its notice of appeal, the prosecution will await the filing of the defense brief and respond to that at the time.
And I would just like to answer a question that a colleague from AMP sent and who was able to attend, which might be of interest to you as well, which is regarding request for the tribunal to confirm whether the team of Serbian doctors will be coming to visit Ratko Mladić, which is a news published in Sarajevo, in a Sarajevo Daily yesterday. And as usual, I would like to reiterate that every accused, including Ratko Mladić, has the right to request a visit of any specialist of his own choice. And this can be approved by the tribunal in accordance with the rules and has been approved on many other occasions previously. I can say, and again repeat, that the registry has been communicating with the accused, the defense and the government in question for quite some time now, making clear its readiness to facilitate this visit and to approve it in accordance with the rules. And we finally have pinpointed the dates when the visit will take place. As usual, I cannot discuss the details of what or who will be examining the accused or what the results of the examination will be, but indeed the team of Serbian doctors should be coming to the tribunal's detention unit sometime next week. I would once again like to reiterate that this wouldn't be the first time that a specialist or a doctor has been to the detention unit to examine an accused before this tribunal, and neither is this the first time that doctors from the former Yugoslavia are examining the accused from the tribunal's detention unit. And one more question that I have received, which pertains to asking for an update on when the tribunal is expected to wind down its work. We are still guiding ourselves with the completion strategy report provided by the President to the Security Council this summer, and the latest report will be made later this year. And we are taking all measures to complete all the remaining work no later than end of December 2014, pertaining to the first instance trials. Also, as a reminder, all the cases on appeals that are not finished before the tribunal or have not commenced, the appeals have not been filed before July 2013, will be carried out or dealt with by a special body called the residual mechanism, which will start functioning as of next year for ICTR and as of 2013 for ICTY. No more questions? Thank you.